it irregularly and craftily sought to convert political grievances into constitutional disputes, contrary to the Supreme Court decision in Sonko. Pursuant to the Supreme Court's advisory opinion in Speaker of the Senate versus the Attorney General, UDA urged this court to exercise restraint and avoid interfering with the proceedings of Parliament, except in the clearest cases of constitutional violations. The 10th respondent filed written submissions dated the 24th of August 2026, which were highlighted by Counsel Dr. Adrian Kemodo. On the procedure for impeachment, UDA submitted that Article 151 provided for the grounds of impeachment of a deputy president being gross violation of a provision in the Constitution or any other law, serious reasons to believe that the deputy president had committed a crime under national or international law or gross misconduct. It's admitted that Article 152 applied the provisions of 144 and 145 with necessary modifications to the removal of the deputy president. The UDA submitted that having been accorded a right to be heard both at the National Assembly as well as the Senate's stage and to be represented in the proceedings, His Excellency Gachagua was found culpable of publicly attacking and undermining the work of the NIS and its officials, undermining the institutional, functional, and decisional independence of judges, and persistently making inflammatory, reckless, and insightful public utterances threatening to discriminate against and exclude sections of the people of Kenya from public service appointments and allocation of public resources amounting to gross violation of the Constitution. It was submitted that the charges were proven to the requisite standard and that the procedure of impeachment under Article 145, 1 and 2 of the Constitution, as well as the applicable standing orders, was followed to the required standards. On the nomination and approval of H.E. Kindiki, UDA submitted that Article 149(1) of the Constitution required the President to nominate a person within 14 days of a vacancy arising and the National Assembly to vote on the nomination. It was submitted the article did not contemplate an appointment, approval of an appointment, nomination by a political party, or the holding of an election as erroneously alleged by the petitioners. UDA submitted that His Excellency Kindiki was nominated within the 14-day period. The National Assembly voted in support of the nomination on 18th October, which was within the 60-day period, and the Speaker of the National Assembly published the resolution via Gazette Notice 13401. It was submitted that the nomination, approval, and swearing in of His Excellency Kindiki were all done in accordance with the law and without any violation of Article 149 of the Constitution. UDA concluded by submitting that the people of Kenya, through their duly elected representatives in the National Assembly and the Senate, had impeached His Excellency Gachagua in order to safeguard integrity in leadership in accordance with the Constitution, the National Assembly and Senate standing orders, and all applicable laws. It was submitted that the decision to impeach His Excellency Gachagua reflected the will of the people of Kenya, which the court should uphold, and that the consolidated petitions were without merit and ought to be dismissed. I look at the 16th respondent's case. That was the IEBC, responded to the consolidated petitions through the replying affidavit of Marjan Hussein Marjan, the then Chief and Commission Secretary, deposed to on the 25th of October 2024. IEBC refuted the petitioner's claims that it was legally incapacitated deposed to on the 25th of October 2024. Its case primarily addressed two distinct legal issues raised by the petitioners, namely the constitutional validity and capability of IEBC as currently constituted, and the purported role of the IEBC in clearing or approving a deputy president appointed under Article 149 of the Constitution. IEBC refuted the petitioners' claims that it was legally incapacitated due to the vacancies of the commissioners, and that it is an independent commission with perpetual existence established under Articles 88(1) and 253 of the Constitution, as read with Section 13 of the IEBC Act. Specifically, it relied on Section 7(3) of the IEBC Act, which states that the IEBC shall be properly constituted, notwithstanding any vacancy in its membership. It was its deposition that Sections 11A and 11(2) of the